A civil society group has urged the National Judicial Council, NJC, to do a thorough review of the current tribunal decisions made across the state, alleging double standards by judges who, the group says, delivered contradicting decisions. The Citizens United for Democracy, while addressing the media in Abuja, faulted the decision of the National Assembly Petitions Tribunal sitting in Jos, Plateau State, which disqualified the elected members of the People's Democratic Party based on pre-election matters. However, the deadline for the conclusion of disputes before the National Assembly Election Petition Tribunals will end this Saturday, September 16. While the next phase will move to the Court of Appeal, there are already winners and losers in the decided cases.
There are a few upsets in the Senate. In Benue State, a former governor, PDP's Gabriel Suswam, was declared winner of the Benue Northeast Senatorial District after nullifying the election of APC's Emmanuel Udende. In nearby Plateau State, the immediate past governor, Simon Lalong, now a minister, was declared winner of the Plateau South Senatorial election. The tribunal invalidated the declaration of Napoleon Bali of the People's Democratic Party as the winner. In North Central State of Kogi, the tribunal declared Natasha Akpoti Uragan of the PDP winner of the Kogi Central Senatorial District and invalidated INEC's declaration of Abubakar Sadiku Ohiare of APC as the winner. The situation in Delta State is different. While the ruling on the petition filed by PDP's Ihioyota Amori challenging the declaration of Ede Dafione of the APC as winner of the Delta Central Senatorial District, the tribunal ordered a rerun in 48 polling units. In Anambra State, tribunal ordered supplementary election in some polling units in Inewi North, South, and Ekusigo Federal Constituency and nullified the election of Abgas Uchenna Elodimo in Oyi and Ayamelum Federal Constituency. The tribunal also ordered a rerun in some polling units, nullifying the election of Abgas Morin Gwacham. Many of the upsets were recorded in the House of Representatives election. In Abia State, the Labour Party was hit hard. Daniel Okeke of the APC was declared as winner of the Aruchuku Ohofia Federal Constituency, nullifying the election of Okwara Osonwa of the Labour Party. In Aba North-South, Emeka Namani of the Labour Party, who was declared by INEC, was sent packing, and Alex Ikwechegi of Abga declared winner. And in Isikwato Umunechi Federal Constituency, Minister of State for Labour in Kiruka Onyejocha of APC was declared winner as the tribunal sacked Amobi Oga of Labour Party. Still in Abia, the tribunal sacked Munachima Lozie, also of the Labour Party, who was declared winner of Obingwa Osisioma Ugunabo Federal Constituency and ordered a rerun within 90 days. In neighboring Imo State, for Obuo Ihite Ubuma Ihio Mbano Federal Constituency, Jonas Okeke of the PDP was shown the way out and was replaced by APC's Chike Okafor. Ikenga Ugochinyere of the PDP was sacked as representative for Idiato North and South Federal Constituency. The tribunal ordered a rerun between Labour candidate Pascal Obi and APC candidate Chika Obazi Ugochinyere would not participate. The tribunal in Bayelsa State set aside the election of the member representing Sagbama Ekeremo Federal Constituency at the House of Representatives, Fred Agbedi, and directed INEC to conduct a supplementary election within 90 days in some polling units and wards where voting was marred by violence and other irregularities. In Enugu, Cornelius Naji of the People's Democratic Party was declared by the tribunal as winner of Enugu East Isuzo Federal Constituency. He will replace Professor Sunday Nnamchi of the Labour Party. In Cross River State, tribunal ordered a supplementary election in 19 polling units of Akankpa Biase Federal Constituency. INEC was asked to retrieve certificate issued to Emil Nyang of the APC. In Kano, the APC was the beneficiary of the judgments. The election of Idris Dankau of the NNPP for Kumbotso Federal Constituency was set aside, and Munir Angudi of APC declared winner. Mukhtar Yerima of NNPP, who was declared winner of the Tarayuni Federal Constituency, was replaced by Hafiz Kawu of APC. And Musa Ilyasu Kwankwaso of APC was ordered to replace Yusuf Umar Dati of NNPP for Kura Madobi Garum Malam Federal Constituency. In Plateau State, Atang Azi of Labour Party was declared winner of the election into Jos South and Jos East Federal Constituency. He replaces Musa Bagus of the PDP. The tribunal also declared Vincent Vinmark Bulus of APC as winner of Langtang North and South Federal Constituency and removed Benny Lar of the PDP. In Katsina State, APC's Abubakar Yahaya Kusada was declared winner of the Kankia Kusada Ngawa Federal Constituency, removing Samuila Kusada of the PDP. The tribunal sacked PDP's Aminu Ahmad Chindo as winner of the Katsina Central Federal Constituency and declared Sani Aliu of the APC winner. The tribunal declared election into Kankara Faskari Sabuwa inconclusive, overturning INEC's declaration of PDP's Jamuila Muhammad as the winner. The same fate also befell election in Basari Safana Musa Federal Constituency. The election of Aliu Ilyasu of the PDP was set aside. The election was declared inconclusive following a petition by Abdulkadir Zakka of the APC. And in Lagos, the tribunal ordered a rerun of the Etiosa Federal Constituency election and nullified the return of Thaddeus Atta of the Labour Party, stressing that many voters were disenfranchised across 33 polling units where elections did not hold.
Joining us now on the morning show to review the National Assembly election petition tribunals so far are two legal practitioners, Liborous Oshoma and Fred Nzeakor. Gentlemen, thank you very much for joining us on the morning show. Well, Fred, you are with us in Lagos here. Well, what we know is that in line with Section 285, sub 6 of the 1999 Constitution, all election petitions have to be concluded within 180 days, and that will be by September 16. Over 400 petitions at all levels, presidential, state. Now, most of those, all of those petitions have to be determined by September 16. What we have seen on the screen is, the various decisions that have been taken by the tribunals, with most of the parties concerned, the losing parties saying they will go to the Court of Appeal. We know it's a process, but what do you think, of what has been done so far in terms of the implications for our democratic process and also for the parties concerned? And the same question also for Liborous Oshoma as we try to open up this conversation. But let's start with you, Fred Nzeakor.
Thank you.
Here in the studio.
Thank you very much. Good morning. Good morning to our dear viewers. I feel so sad. I feel so disappointed that our democracy is not growing in the direction we expected it to grow, in the direction that will bring development to the country. You mentioned 400 cases. I can tell you, Ruben, that they are the ones that are yet to be decided. Some have been decided. There are over 560 cases, election petitions, all across the country. And what it now means is that National Assembly, you have 469 members on the whole, and you are looking at over 550 cases. That means an average of more than one case per legislative seat at the federal level. So what's the implication? The implication is that INEC has failed Nigerians so woefully, so massively woefully, that you now begin to doubt whether the votes of the people count anymore. You now begin to doubt what is the whole essence of bragging or spending over 350 billion naira in conducting an election that will end up in courts, and more expenses will be incurred because INEC has to come and defend. In all cases, INEC is a party to the cases. And above all, recall that apart from the budgetary allocation from Nigeria, there were also contributions by development partners all around the world, with the hope that our election is going to set the pace for Africa in the direction of civil democracy. Now, not only that money is lost, precious legislative time is also lost. Election will take 180 days. Appeal will now come. In some cases, there will be a rerun, which the court will say, conduct a rerun within 90 days. That's another 3 months. So give and take, 1 full year, we go into post-election issues, litigation, and the rest of them, which will distract the legislators from doing their work. They have only 1 year is gone out of 4 years that they have been elected to serve. The next 2 years will be the only years that they will work, because the year penultimate to the next election, politicians will now go back and begin to prepare for the next election of 2027. So what it now means is that we have a 4-year tenure, but we have 2 years of active work. And that is why a lot of the laws that are yearning to be touched are not yet to touched. A lot of the laws that are even touched are now hurriedly churned out, that they bring a lot of confusion into the system. We jubilated when 2022 Electoral Act was signed into law, only for us to find out that there are still so many loopholes about issues relating to INEC guidelines and the rest of them that we are not adequately captured in the Electoral Act. So the implication is that our democracy is not moving on the direction of growth and development. If at the end of the day, virtually all the election issues will end up in court. Not only that, it is engaging the judges. For National Assembly elections alone, you are looking at 36 states of the Federation and the FCT. That is 37 petition panels that will sit, 3 in each one. You are looking at 101 judges sitting in petition at the Court of First Instance. And now more justices will now sit at the level of the tribunal, at the level of the appeal. Many issues that are yearning for attention in the courts are stagnated because the judges are facing election matters. So how does it affect inflow of investment? A foreign investor who wants to come in and finds out that when you have matter in Nigerian court, it will drag for ages before being resolved. Pure civil matter that ordinarily will be resolved timeously is not resolved. Our alternative dispute resolution mechanism is not well firmed up, because there are many issues that when you even get an award from the alternative dispute resolution mechanism, you don't get to harvest the fruit of your award. You now still have to go back to litigation. So many things I can tell you need to be attuned, need to be fine-tuned, so that our election will be determined at the point of polling and not everything being emptied into the courts of law, because it gives a lot of problems to the system, a lot of innuendos that now begin to impugn on the integrity of the judiciary. Well,
Liborous Oshoma in our Abuja studio, what do you think? So many ins and outs. So is it the Nigerian people deciding or the courts? Your thoughts on the implications for the entire democratic process and the judiciary, as Fred Nzeakor has pointed out?
Thank you, Doctor. What I think, first and foremost, is that with all of these verdicts coming from the various tribunals, even though we are still waiting for the Court of Appeal to decide most of them, and then soon we'll also hear from the governorship election petition. What I think has happened is that surreptitiously the courts has given INEC knocks. We've never, in the last, even in 2015, we didn't have this myriad of upturns, and also in 2019. But what you're saying is upsets. What that means is the courts indirectly, without saying it, is giving INEC knocks. And I want to quickly also correct a statement by my friend and brother, Fred Nzeakor. It is not one panel per state. In some states, you have about 3 panels. That's about 9 judges. off their work. Mind you, these judges also have civil or criminal matters they are handling in various courts. So for all the time they are at the tribunal, the matters they have at the various high courts, or even at the magistrate court, will be put on hold. So in some cases, you have about 3 panels, 3 panels, three judges in one, and then in some you have 2 panels. So because of depending on the number of the cases. So, but in this case, what also had happened is the fact that apart from the knocks, what also we see playing out here is the fact that elections. If you remember, when APC were in opposition, the burden of proving election irregularity consistently was a topic for debate. I remember people like Alhaji Lai Mohammed then saying that the burden should not be resting on the petitioner, who participated in the process, but on INEC, who conducted the election. But a situation where the burden of proving irregularity is on the petitioner who participated. The man who conducted the election, no matter how irregular the election is, once he announces result, that result is presumed correct. The law already presumes it's correct until the courts pronounce otherwise. And then when the participant goes to court, the umpire becomes a nominal party in the matter. And certainly he would defend that which the law has presumed to be regular. So once that happens, you're going to have this, win at all costs mentality, and then the attitude of you go to court. So what should be done? I think most times we say these provisions also derive from section 36, 1 and 5 of the Constitution, presumptions of innocence. But also I think we can tinker, because when now APC is a government, all of those things that they agitated for, those amendments that they so hard pushed while they were in opposition and that PDP rejected, today nobody is discussing it. So I think now what we should be discussing is, how do we ensure that the burden of proving irregularity is placed on the man who is conducting the election, to show that if you say, for example, that you're going to follow a process through, and that process truly is followed seamlessly. If you look at Regulation 93 of INEC guidelines made pursuant to section 60 to section 66 of the Electoral Act, right there, INEC stated that collation, they shall do collation, using the Form E-C-8A. And when Form E-C-8A fails, they shall resort to result uploaded on the IREV. And when you do not have result uploaded on IREV and Form E-C-8A, they shall resort to result handed over to the police or to polling unit officer. Nobody talked about these regulations when INEC consistently were saying they were going to transmit election results on online real-time. But they had a regulation that talked about transmitting collating manually. So all of this issue, but if there's a burden placed on INEC to come show how the process was seamless, I think INEC would do everything possible, knowing fully well there are 2 hurdles to cross. The first hurdle will be conducting a credible election, and then the next hurdle will now be to show to the court that the elections truly were conducted in compliance with all the laid down rules. Until we do that, once you shift the burden of proving this irregularity to the petitioner, it is not in all cases that the burden becomes very easy. When it's about take for example, when it's about qualification, these are issues that these are points of law. It becomes easy to prove. But when you talk about numbers, for example, it is not too easy to prove numbers, except like in the case of Senator Dafinone and Senator Amori Igoyota. Those ones are a margin of lead that like it happened in Kogi, where you say the number of those disenfranchised in that constituency, if are allowed to vote, the margin of lead, it will be more than the margin of lead. In such cases, the tribunal will say, well, you go back and conduct elections in these places. And it happens in so many places. But where it has to do with numbers and the constituency is wider, the bigger it is, the more difficult it becomes to prove this irregularity, especially when you have to prove polling unit by polling unit, the said irregularity. So I don't think there should be unnecessary burden placed on a man who participated in the election and who everybody sees that were flawed, and then you now tell him legally that he should come prove that the election were flawed. And then the materials, most of the materials for proving these irregularities also would not be with him. Some of them would be with the man who also participated, who conducted the election. And then he needs to go to court to apply for these materials. And the law also says, you see the conflict. The law also says that once you are coming to court, you must file all your documents and all the witnesses that you're going to use. So any material obtained subsequently after petition had been filed is of no use to the tribunal. So why put that burden on the petitioner? Why don't you shift the burden on the man who conducted the election? Why do we presume that once election results are announced that they are regular and that they are correct, it is you who is alleged that must prove that they are not regular? Considering also, quickly, let me round up on this, the fact that all of the national commissioners, the state electoral commissioners, and the national chairman of INEC are appointed by the ruling party. These were some of the recommendations of the Waste Panel report that we have completely jettisoned. Until we go back to all of those issues, we'll consistently have this petitioned year in, year out, because government seems to be the only employer of labor now, apart from, every other, maybe some major private sector.
Thank you so much, Mr. Oshoma. Now, with these developments, there's been a call, or perhaps the reality, that we need to revisit the Electoral Act, even though it was praised as, going to be quite instrumental in having a more transparent and efficient election. Unfortunately, with what we've seen now, it doesn't seem to have fully, responded to the need in that particular area. So going forward, and in order to avoid, I know you've given some recommendations in terms of strengthening the institution, and perhaps I'd like you to speak a bit more on that. How do we strengthen this institution, INEC? You made reference to the waste report, you made reference to appointments of commissioners in itself as a starting point. But another thought is around even consequences as well. Because this is a big indictment on INEC. The fact that the election that they conducted has in many areas been faulted, has been flawed, marred with irregularities and the likes. Should there be any form of consequence, perhaps? Should INEC be made to answer for why, that huge amount of money was allocated, and yet what could be described as quite a shabby election was conducted? And then the Electoral Act itself. How do we ensure that the law favors more credible elections in Nigeria? Then before you respond, Mr. Nzeakor, the question I'd like you to respond to after he does is, with regards to patterns and trends, are there any patterns and trends? Yes, in the last few days, we've had representatives from Plateau and also from Abia State, where we looked at pre-election matters. One, PDP not having a structure in Plateau State, the other, primaries not conducted in the constituency. I'd like you to share with us some patterns in the election. But before you respond, Mr. Oshoma, please.
Yeah, thank you. The issue here is INEC, because the law presumes INEC's action and act to be regular, it becomes difficult now for you, even as a petitioner, even as a court, tribunal, nullifying the election, to give INEC, for there to be consequences. The consequences will just be go back and redo the process. It's like a process was rigged, and you say go back and re-rig the process. So my point is, first and foremost, we need to participate more in the local government elections, because government at that level is closer to the people. When you have robust local government participation and governance at that local level, there will be less people interested in going, to the center, and the rancors with the election at the center will not be much. Secondly, on the INEC the National Assembly donates with one hand and then allows INEC to take with another hand. Before, in 2003, before the 2003 election, there was an amendment in 2002 to the Electoral Act to correct the defect of the 1999 election. In 2007, there was a 2006 amendment. In 2011, there was a 2010 amendment. And just like that, you keep having amendment. 2013, we have 2023, we had 2022 amendment. But most of these amendments, like the 2015 election, what happened in that election was there was the issue of card readers, for example, was a major issue. And the Supreme Court said, well, since it's not part of our Electoral Act, you cannot be discussing over voting and then use card reader. Rather, you will use the voters register. That was what happened in Dagogo Peter Side's case and the Yeson Wike. And so the amendment in 2012 beautifully added that provision that INEC shall use a device to accredit. But we also forget that now you're not talking about collation. You now leave collation in the discretion of INEC. While INEC in one breath was telling you we're going to use electronic device to transmit result. In another breath, in Regulation 93, they are saying that we are going to collate manually. It is only when the manual result, the hard copies of the manual result are not available that we resort to online. That is the discretion you left to INEC. So even if, in spite of all of this, if you place the burden of proving regularity, the law does not presume that INEC, you are right in whatever you do. Because that's what the law had done for them. INEC, whatever you do, if you like, lie to Nigerians, you are right. That's what the law had done. If you conduct election, INEC, the moment you conduct election, you are right. Once you announce result, you are right. It is now the man who is saying you are not right to come and prove that you are lying. How can you? It is not possible. So the National Assembly, that's why also we need to be very interested in the election to members of the National Assembly. Because the people around the corridors of power are more than those are stronger than those in power. So if you have a strong National Assembly that always goes back to consult, a situation where you talk about public hearing, but indeed there are no public hearing. When you go back to consult, and then all of these issues will be discussed robustly, and then included in your laws, and then you have a situation where INEC, the pressure will be more on INEC. That should be the consequences. The pressure will be on them that knowing fully well that when you conduct an election, certainly you are going to be asked to show how the election was conducted. But in this case, all of the political parties know. They know this provision, not that they didn't study it. They studied the INEC guideline, they studied the regulations, but they all thought that they will win. If PDP had won the election, for example, this would have been the same complaint of APC today. That no, they should have transmitted election result real-time online. That was what they promised. But PDP will be saying the rule allows them. The rules permit them because it happened before. So, but if the burden, if we pressure the National Assembly and lawmakers, starting from the local government to the state assembly, to ensure that the onus of proving irregularity is on the man who conducted the election, because he has all the materials, he has all the apparatus to conduct election, and not on the person who is a participant in the process, then we would have shifted to a situation where when you are conducting an election, at the back of your mind, you will know that you have a second hurdle. And at that, with that, what will happen will be that, you have strengthened that institution to a certain level that is a responsibility placed on them. That if the election, the consequences is that if the election is not conducted properly, you're going to explain.
Absolutely. Thank you very much, Mr. Oshoma. Mr. Nzeakor.
Yes, I want to agree with Liborous about the issue of sanction. There has to be sanction on INEC. Yes. There has to be, something must give. When a judge misconducts himself, he's being called to question by National Judicial Council. The law must provide
all eyes on the judiciary.
Yes, I mean, apart from the
those eyes went to the court.
Apart from the public, apart from the eyes of the public on the judiciary, the National Judicial Council has a responsibility to sanction erring judges in Nigeria. An institution must be established by law to sanction INEC, because the way INEC is going, the issue of presumption of regularity, which Liborous has elaborated upon, yes, I agree with that, but if it is large on presumption of innocence in criminal adjudication, this is a civil matter. Election issues are purely civil. So we will not presume innocence of INEC in this matter, because INEC is the major problem, the major culprit. When Nigerians are giving them all necessary support and cooperation, they fall the hands of Nigerians. They don't keep their promises. They don't even implement their guidelines. And what do you call it in local parlance? It is 419.
Bad way.
INEC is doing Nigerians 419.
I mean,
I can understand it is important that they be called to order. It's important that an institution should be there, established by law, to call INEC and INEC officials to order, so that this mercantilist political election management should not be the one, because it cannot take us. It cannot take us further.
Fred, no, hold on a minute.
Yes.
Their lordship spoke about substantial compliance.
When you talk about,
which is a major issue in electoral election petitions, which Justice Samani reminded everybody are sui generis.
They are sui generis. Yes, when you talk about substantial compliance, we need to put measurable standards to that level of substantial compliance. It has to have, if you conduct an election in 469 National Assembly seats, and you are faced with over 550 litigations across the country on account of 469 seats, that is a knock on INEC. Okay. It's a very obvious knock on INEC. Now, when you now look at the patterns and the trends, you now see that INEC has exposed the judiciary to a boomeranging effect, so to speak, where the judiciary is now running like a pendulum, swinging left and right, in some cases in confusion. And that is why in some of these matters, in some of these adjudications, in one hand, judiciary will say pre-election matters, or rather political affairs, issues about nomination is internal affairs of political parties. In another dimension, the same judiciary will come and latch in on that to give judgment. So that tells you that there's a lot of inconsistency. And what is the cause? Because politicians and INEC will not do the thing the way they are supposed to do. So while we are also looking at INEC, the judiciary needs to really firm up electoral issues, because it is giving it a very bad name. There's a lot of inconsistency in political adjudication. Why would 1 minute?
Yesterday we had Odusio on this same program, and he said, with regard to this point, about conflict in the rulings, that every matter should be taken on the basis of the facts of the case, and that the facts of the matters of the cases are not the same in all instances. It may not be and I thought that was an intelligent point that Odusio made yesterday.
There is an issue of judicial precedence, which must always.
He also addressed that yesterday.
Which must always
he also addressed that yesterday.
Okay. Yes. I would like to ask my set of questions. Number one will be, we have talk ad nauseum. After every election, it's always a talk shop. We talk. In fact, we over talk, but we don't do anything. As we speak today, I'm going to ask both of you, what are the areas we should pinpoint to take back to the National Assembly to start fixing in our electoral laws? If possible, let's also look back at the waste reports. What are the areas there that we are not implementing? Like Mr. Liborous said, one, about the fact that who even selects the INEC chief?
That is one aspect.
That's one aspect. So what are the key areas? If you can itemize 5-10 of them.
Yes.
The areas you want us to take back to our National Assembly, and we effect as we speak today. Mr. Liborous will come to you on that question, because we've just been talking. We'll get no way forward if we don't ask this.
We will not stop mentioning recourse to waste reports. We must go back to that report and bring out the fine ingredients of that report to strengthen our electoral process. In doing that, we must look at who appoints the national commissioners and the electoral commissioners. You recall that during the build-up to this election, we shouted to high heavens that the ruling party was populating INEC with card-carrying members of their party. We shouted, we gave instances. In one particular occasion, the president withdrew one lady and replaced her with another lady. And we shouted that we are populating INEC with manifestly partisan people. Now we are seeing the results. Unfortunately, the parties in opposition did not escalate our talk to the level where the ruling party would be conscious of the opinions of the people. That is one aspect. The second aspect, INEC has been given a lot of latitude. Here the Constitution and the Electoral Act says INEC should conduct election in the way and manner they deem fit. That way and manner they deem fit has given them too much latitude to operate their discretion, which their discretion has turned out to be indiscretion. The foot of the chancellor being worn by INEC has become so loose that we need to now bring some of those guidelines in a straight jacket so that the room for discretion or indiscretion in this case will be very limited and very minimized, and INEC will now operate by the rules. There's no reason why INEC will tell Nigerians that election results will be transmitted real-time online, and they fail to do that, and the heads are not already rolling.
That's Badware.
Right?
That's GBT.
So, and heads are not already rolling. So, that is the second aspect of it. The third aspect of it is that we need to educate the people. Yes. We need massive public education so that people will understand that it is not a case of nadendem. If you say nadendem, their actions will somehow directly and indirectly affect you. Why on earth would somebody become a legislator at national level by law with school start attempt in this modern day and age? Well, on earth, these are all the areas that we need to touch. That we cannot have large number of learned, intelligent, brilliant, educated people, and you now lower the bar to accommodate some money bags who themselves do not even know how to write their names. There are people in National Assembly that for once never stood up to argue an issue, even to introduce themselves. There are people there, and then they still stay there for 4 years, and time is going. At the end of the day, they go home with fat pay, and the people are using the short end of the knife. So these are all areas that need to be adjusted. And finally, you now look at the issue, because if constitutionally matters are allowed to be adjudicated in the court after election, it's a process, starting from primaries down to decision, final decision of the court. We also have to look into that aspect. Okay. What the court says and what the court should not say. Okay. There must be precedent so that there should be, you should be able to say that if you have done ABC, you expect XYZ. Okay,
Mr. Liborous, I'm sure you want to chime in on this. Mr. Oshoma.
Yes, Rufai, it is not that we are just talking and we are not doing anything. We are talking, and at every point that we talk, we put pressure on the National Assembly, and there is an amendment. And that is why I read out all of those amendments to you. From 2003, you had Electoral Act 2022. 2007 election, you had Electoral Act Amendment 2006, just like that. And also, in 2015, like I talked about, the card reader was introduced. It was not part of our Electoral Act. And people said, no, you can't use this card reader. And then the Supreme Court said it wasn't part of it. And so there was an amendment to the Electoral Act to accommodate an electronic device. So what we have, like I said, if you look at Section 133, 135 of the Electoral Act that Dr. Ruben talked about, that an election shall not be invalidated on the ground that it did not comply with the election, provided the compliance is not substantial enough. Who determines substantiality? It is the court. So when it shouldn't be so, it should be that INEC must comply substantially with its laid down rules and regulations, and so otherwise election would be invalidated. So when you have that, it is INEC, the burden of complying now substantially. It's with INEC. Unlike when you say you come and prove non-compliance, the law already presumes INEC to have complied. So it is you that is saying that they didn't comply that will prove non-compliance. And all the materials and all the ingredients, most of the materials and the ingredients that you need are with the same INEC. And that's on one side. You look at our laws also. Take, for example, I tell you, this is a conspiracy of the ruling class. In 2007, the Obasanjo's administration set up an administrative panel of inquiry that indicted Atiku, and Morris, who was swift to disqualify him from contesting election. And in considering Section 137 sub 1 of the Constitution, the court said you cannot disqualify a candidate on the basis of an indictment. As it is only the court after trial that can disqualify a candidate. The Supreme Court also, in its wisdom, recently reiterated that for pre-election matters, for you cannot contest the primaries of a candidate if you are not a party in that, if you are not a member of that party, or you are not a member, you did not participate in the primaries. And so, if you are in a Labour Party, for example, you cannot go to court after the APC primaries to say, oh, this person was not validly nominated, except after the election and you are a candidate in the matter. So, but a lot of people also miss this point. And that's why the fact of each case differs. When it is a post-election matter, a candidate in an election can validly question the qualification of the winner in that election. So, but now going to the areas where after this election now, INEC needs to. We need to put pressure on INEC. The same way we put pressure on INEC to include card reader or beavers in the Electoral Act. Also, is the same way we also need to put pressure on the National Assembly now to shift the burden, not only transmitting election results real-time online, because also we need to talk to Nigerians, especially political parties. A situation where people now attempt also to break into these electronic devices. What happens? That's why it is not just saying transmit election result real-time online. There is no way that can be possible without putting a burden on INEC that when you do it, you will need to show that you follow the processes and the procedures for doing that. And also we need to strengthen our local governance level. Look at what happened in Edo we called it local government election in Edo State. Can you truly call that election? Why we are complaining about election at the center? What are our state local government, our state commissioners doing? It is even worse than what we have at the center. So we also need to strengthen local government. So once you have a strengthened local governance at the local level, it becomes also difficult for everybody to be so interested in manipulating the process. So apart from the positions of the rest of the electoral commissioners and the national commissioners and the chairman, who should be removed from the hands of the president. That was the argument of the ACN then, APC, where they were in opposition.
On that note, Liborous, I would like to thank you very much for joining us, Liborous Oshoma, and also Fred Nzeakor, who is with us here in the studio in Lagos. Gentlemen, thank you very much indeed for your time and insights.